Hello, and welcome to today's webinar presented by EPAY Systems. Today's webinar is Legalized Marijuana and HR, the Law, your Handbook, and everything in between. Thank you for joining us today. My name is Michelle Lanter-Smith. I am the Chief Marketing Officer here at EPAY Systems, and I'd like to welcome all of the listeners across the country that have joined us. I'd also like to welcome our guest speakers with us. So thrilled to have them and their expertise. I think you'll find it to be very enlightening and helpful. So first, I want to introduce Special Counsel Jennifer Long of Duane Morris. Jennifer practices management-side employment law with a focus on prevention of workforce-related issues. She conducts numerous employee and management training courses annually, including anti-harassment, discrimination, and retaliation training. And she acts as a primary defense attorney for discrimination, harassment, and other improper employment practice claims. Welcome, Jennifer.
Thanks, Michelle. Hi, Anna. Hi, everyone on the line. Glad to be here today.
Anna is an HRCI certified HR consultant at EPAY Systems. She works with our clients to help build handbook policies, harassment training courses, and other HR-related topics. Anna brings over 10 years of experience with a unique perspective gained from working with large hourly workforces. Welcome, Anna.
Thank you. Thank you, Michelle. Thank you, Jennifer. And thank you, everyone, for tuning in today.
All right. Well, here's a quick overview of what we're going to be discussing today. You'll see the agenda up on your screen. Jennifer is going to start us off talking about the law and marijuana. And then Anna is going to go in from an HR perspective and talk about updating employee handbooks, how you actually go through and document and what you do when you suspect somebody might be under the influence of cannabis, and then some HR tools for easing this and how you can really make sure that you are complying to the law and, keeping things straight. But before we get started, I have a few housekeeping items. As always, don't we always have housekeeping items? I think the best way for all of you out there to really get the most out of this is to participate. So we're going to include a number of polling questions throughout the session today so we can all gain more insight of what you're dealing with out there, and I think it'll help you to see what your colleagues are dealing with. The polling questions, they're easy. They're placed throughout the webinar. All you got to do is answer on your keyboard, okay? You can earn SHRM credit for today, so that's the great news. Just got to stay on to the end and finish a quick little survey at the end, and we'll email your SHRM code. And then, of course, we welcome your questions. We're not going to open the lines. The way we're going to do it, since there's so many, we have hundreds of folks on the lines with us today. We are filled to capacity. We've been seeing with these topics that we fill up pretty quickly, and we are capacity. So the way what we want you to do is if you would just type the question in on the right side of your screen. There's a little box called questions, and you can type your questions there. Our organizer, Emma, will be watching for those, and she might chat with you and say, hey, we're going to get to those later, or she'll try to answer for you. So she can chat back, but she'll bring them forward to us and pretty much probably more towards the end of the session. And then finally, final household tip, sometimes it's best to learn and see how others are doing things. So after each topic up here, we're going to share best practices of how companies use our HCM technology to ensure compliance and promote communication with their employees. All right, so a little bit about EPAY Systems and who we are. We were founded in 2001. We are a full human capital management provider, from applicant tracking to HR, onboarding, time and attendance, payroll, and performance management. Where we specialize is we focus on employers that have a large hourly workforce and tend to be in a very distributed environment, so their employees are moving around from job to job, might not have a lot of supervision on site, and so on, which really causes these HR nightmares. Anna is very knowledgeable of this environment, and she'll be talking a lot about her experiences in that HR hourly workforce. Our real strength, we have a full solution, but people come to us because of our workforce management. It's very robust, and it really helps track that hourly workforce and give you the data and tools to get through. And then also, because we have great 24/7 support, you can see some of our most recent awards up there. All right, well, let's get started. Actually, we're going to do a poll right away. We're going to get you guys engaged right away. So we're so excited to meet you and excited to see what you have to say. So here is the first poll coming up on your screen. Do you operate in a state that has legalized recreational use of marijuana? Yes or no? All right. So, wow. Okay, you're almost all in. 74% of you have voted. I'm going to close it now. We're about half and half. 48% say yes, 53% say no. So about half and half there, Jennifer. So pretty interesting. But I think you've got advice for both.
That is interesting, and I'm glad we got that feedback from a good portion of the hundreds that are on the line. The reason that is interesting, and my role today here, just to be clear, is to give you a very broad overview of what is going on in the arena of legalizing cannabis in the United States. And so we're going to hit on all the key touch points and just give you some background for what you need to know about the laws that impact your business as you're making these policy and practice decisions for your particular workforce. And the reason I find that interesting, it was almost a 50-50 split, 46 yes, 54 no the last time when we closed that poll, is that it seems from the legislative arena, we are hitting a tipping point. As you can see here, we now have in the United States adult use cannabis, or what most people would refer to as recreational marijuana, lawful in 11 states and the District of Columbia. That dates back to 2014, with Colorado and Washington being the very first states. The most recent being Illinois, where I practice, and you'll hear a little bit more about our recent law. But we are moving forward rapidly in this arena. In the past, I would say 18 months to 2 years, there have been 20 additional states. So that's on top of those 11 states that have passed it, that have raised bills within their legislative processes or that are still pending. There's a number of states that still have them open in their current legislative sessions, which ordinarily close around Memorial Day or the 1st of June, depending on your state. And then we have 4 states, in addition to those 20 states with bills raised, 4 states that have to pass the legalization through a ballot measure, meaning that it has to be voted on. And so we have 4 states across the country that measure to legalize recreational marijuana is on a ballot in 2020. And so you can see that depending on the way voters and legislators move forward, that this easily could be rapidly increasing the number of legalized states. In the meantime, medical cannabis has been around much, much longer. You may not be aware of it in certain states, but it has been around in California since 1996. So we are nearly 25 years into lawful medical cannabis out in California. And we have well over half the states that have legalized medical cannabis, with 33 states and the District of Columbia having medical cannabis laws already on the books. There are a number of additional states, even beyond those 33 states, that have recognized the medical validity, if you will, or the medical appropriateness of cannabis without actually legalizing. And what that may do is allow them opportunities to do different things with medical cannabis, but not allow persons to take it home to use it individually. That results in at least 3 million registered medical cannabis patients nationwide, which in some states can be as much as 3.5% of that state's population. And so why am I telling you all these tidbits? Because if you don't think that you have employees that are engaging in lawful marijuana, you may be wrong. The numbers tell you that you're most likely wrong. So let's flip the slide. And so in states that do protect an employee's use of marijuana, we have a broad variety of approaches. The laws range from simply having a compassionate use law in place for medical cannabis, meaning that they recognize that employees with certain, that persons with certain very difficult healthcare situations, the MS, the late stage cancer or other end of life diseases, can be permitted a compassionate use of medical cannabis. Other states go farther and create a process by which a person that has a medical condition authorized under the state law can become a registered medical marijuana user. We commonly hear that talked about as being a card holder. That's because persons actually physically have to have a lawfully recognized and issued card that recognizes their status, and then they present that at a pharmacy that's authorized to distribute medical marijuana. Usually that's a marijuana dispensary, not your average everyday Walgreens or Duane Reade, etc. And with that card, either the patient or their family member, their caregiver that's been legally authorized, can pick up medical cannabis in the prescribed amount by their physician. Then we have the states that have not yet legalized the possession of marijuana. They may have decriminalized its use or possession, and that's in at least 26 states right now. That means that if you are using a small quantity of marijuana, or that you are caught in possession of a small quantity of marijuana, that you won't face criminal jail time, for instance. And all of this is dependent on the state laws, but these are the various options. And the last one I have up there is that a number of the states, including the vast majority of those 11 states that have recognized recreational adult use marijuana, and the 33 states that have recognized medical cannabis, provide some level of protection to employees against certain adverse employment actions. And that's going to be on the basis of whether you're a lawful card holder for medical marijuana, or in light of a positive drug test under either a medical cannabis situation or a recreational. And so let's flip over. Why does this still leave you in a conundrum as employers across the nation? Because of federal law. No matter what your state says, no matter what your state has or has not done, federal law still says that marijuana is a Schedule I drug under the Controlled Substances Act. That means it is an unlawful substance under federal law. There is no distinction between using it for recreational use or medical, prescribed, authorized use. There are no exceptions under the Controlled Substances Act based on state laws. So whether or not your state has passed a law recognizing medical or recreational marijuana does not matter. And the reason that this is kind of hotly debated, and that there's been various levels of intent to enforce this provision under various presidential administrations, is that Schedule I drugs under the Controlled Substances Act are defined as drugs that have no currently accepted medical use, with a high potential for abuse, and with potentially severe or psychological or physical dependence. There is certainly debate within the medical community. Many members of the medical community take issue with marijuana still being included in that definition, but as of right now, it still is, and it is still unlawful under federal law. So where are we then? Next slide tells us that you as an employer have to recognize all the requirements under both federal and state laws, as you do with many other facets of your daily life as HR professionals. But this one is particularly tricky. In addition to recognizing the requirements of your state law, for instance, the protections that may be granted against taking adverse action against an employee that is not in violation of the state law on cannabis, you still also have to apply your regular old employment laws. You have to comply with the Americans with Disabilities Act, FMLA, your state law disability leave laws. You have, if you're a DOT or other employer that has additional federal regulatory requirements, you have to comply with all of those. If you're a federal contractor, you have to comply with the Drug-Free Workplace Act under either your state, under federal law or under state law equivalents. All of these have requirements that you must comply with, and nothing has changed because your state has passed a law legalizing marijuana. Some of your obligations include providing leaves of absences, perhaps adjusting schedules to accommodate medical treatment. All of those requirements that you have to apply to anybody with a healthcare solution apply to folks that have medical cannabis involved. And you have to make decisions and make sure that you're taking all of these issues into account as you go forward. I'm going to go briefly over, next slide, please. I'm going to use Illinois law as a brief overview. I realize that many of you are not in Illinois necessarily. Many of you are, but it is the most recently passed recreational law, and it also happens to be where I practice. So I have a lot of experience advising companies in this area, and it just went into law as of January 1st, and so we are getting literally minute by minute questions in this area. So we've had medical cannabis here in Illinois since retail sales began in 2015. In this summer's changes, it was made permanent. It started out as a pilot program, but now we have over 80,000 registered card holders since beginning the program in 2014. Then on the recreational side, it was passed very quickly with a new governmental administration in June of 2019, became effective on January 1st, and we are the 11th state. One of the things that is unique to Illinois, California has a similar provision, but there's only a couple of other states that are like this. We also have a special law called the Right to Privacy in the Workplace Act that says that you cannot discriminate against an employee for off-duty, off-campus use of lawful products. Well, guess what? With these two laws now in place, cannabis, as long as lawfully obtained, is a lawful off-duty product. And so you have, in addition to all of your requirements, you have to comply with that. Next slide. I'm going to go very briefly through a couple of things in the Illinois Cannabis Act that, while they are particular to Illinois, so don't take this information and use it in other states without checking your particular law, they are similar to many other states out there. That being said, marijuana law across the country is a crazy situation for employers right now, because every single law in every single state is different. And so if you are a multi-state employer, you will have to comply with the requirements of every single state that you operate in. And the Illinois Act in particular does tell employers, does have a provision, it makes clear that employers don't have to permit employees to be impaired or under the influence at work, on call, or on property. That's great. Thank you. We appreciate that. And most laws across the country have that, but there are many, many caveats and nuances of that provision. One of the practical nuances is that, guess what? There are no great tests available for being impaired for marijuana. It is not like alcohol, where the scientific community is in complete agreement that anyone over a certain blood alcohol level is considered impaired. We do not have that available. We also don't have the available through the science right now to tell you when a person that tests positive for marijuana last used marijuana. A positive test could mean that the employee smoked marijuana yesterday, or in some cases, depending on the test, it could be 30 days, 60 days or more. Certainly, there are many scientists that are working on it. For instance, the state police in all the states where there is recreational marijuana certainly need to have a test to test for impairment for driving, etc. But that's where we are with the science. Next slide, please. Most laws, including Illinois, also provide some level of direction as to what impairment means. And in Illinois, it means that an employer has to be able to provide articulable symptoms of impairment, and Illinois goes on to list them very specifically. And so if you are going to take action based on a person's impairment for marijuana at work, you need to have very clear designation that you saw impairment in these areas. And they're listed there: speech, dexterity, agility, disregard for safety, etc. Illinois goes a step farther for the employee and says the employee has to have a reasonable opportunity to protest your decision. So all of these are factors or things that you have to consider and make sure that your policy is clear and upfront on them. Next slide. The law does provide that you can enforce a zero tolerance drug policy, a drug-free workplace policy, and most of the laws, not all, express that very clearly. However, the campus has to be the focus has to be on during working hours or on campus, particularly in those states that have recognized recreational marijuana. And then Illinois provides a safe harbor for these additional factors. And so next slide, I just want to sum up before I pass it back to Michelle and Anna, that you as an employer need to be in front of this issue and take certain steps to be able to limit, but not eliminate, and that is key, your risks associated with taking adverse actions related to cannabis consumption. First things first, you have to carefully consider whether your company's philosophy will be to deny employment or to terminate an employee based on a positive drug test for marijuana. So what is your position on testing? Even when you make that decision, then you have to just consider when you're going to be requiring those tests. There's a big difference from pre-employment testing and then post-accident or reasonable suspicion testing under each of the state's laws that are in effect, perhaps where you operate. The next slide. You also will have a stronger argument where you have evidence of actual use occurring in the workplace. So it will be important to train everyone on the difference between symptoms of impairment and symptoms of use in the workplace. And then where you can, you should take advantage of what conduct resulted in your finding out about the situation. Can you take adverse action based on another policy violation? For instance, fighting, in the healthcare field, maybe medication errors or other errors in the workplace, and not on the medical marijuana or marijuana use in and of itself, where the use of the marijuana violates other laws, for instance, DOT requirements to be sure, or a Drug-Free Workplace Act requirement. Take advantage of those. Do not base a decision on the individual's underlying medical condition, because obviously that raises red flags. And then can you take steps to show that allowing medical marijuana use would be an undue hardship under your company's circumstances? And so I'm about to turn it back over to Michelle and Anna, but it's clear that you must have, first and foremost, a decision on these issues that is then reflected in clear written policies, that also is reflected in your job descriptions for positions that have key safety or life-threatening factors. And if you are testing, that you have trained your employees on what articulable symptoms are, how to recognize them, and most importantly, how to articulate them in writing. And then specifically what your prohibitions are with regard to the consumption of marijuana in the workplace. So I'm going to turn it back over to Michelle, and I think we're going to get some feedback again for what you're doing so far in this area.
You bet. Thanks, Jennifer. All right, we're going to start our next polling question. We actually have two for you. So the next polling question is do you plan to continue to do drug testing based on what you've heard or what you've been talking about at your company, where the laws are in your state? So it's yes, no, or we don't currently drug test today.
And I love to see this feedback, Michelle, because we have so many folks on the call today.
Okay, we are almost there. I'm going to close it because we got so much to cover. We're 76% in, and it looks like 68% say yes, they test, 3% no, and 29% we don't currently drug test today. So interesting. All right, next question for you. So only answer this if you do currently drug test. Are you going to discontinue, or have you recently discontinued marijuana testing? All right, it's going to be interesting to see your answers. You guys are coming in here. It looks like, oh, half of you have voted. Couple more seconds here. Can tell you guys are hemming and hawing. This one you're a little bit slower on. All right, so it looks like 87% say nope, you're not going to discontinue marijuana testing, and 13% say yes, you are now. Interesting. All right. Well, what I want to talk about real quick, though, is in this area is a best practice that we're seeing some of our customers do. And what they're doing is with their applicant tracking system, you're able to really tie in that drug testing. So, right, it's part of background screening. You might do a background screening and with that a drug testing. And so this can just add a lot of paperwork if you're not truly integrated. So, and obviously if you have electronic onboarding, your paperwork is huge and enormous. So the best way to do this to really get some efficiencies is to integrate your background screening / drug testing with your applicant tracking system, like you see on the screen, where right from the applicant comes in, you decide you want to hire them, and you can order your drug test or background check test right here. And then when the results come back right from the same portal, you can click on it, and there it is. So it's really more an efficiency thing. So that is one of the quick little best practices that we see out there.
So helpful to have that in one spot.
All right, well, let's turn it over to you, Anna. We're going to talk about really how you should be responding and building policies around what Jennifer just talked about.
Yes, Jennifer, thank you. That was so enlightening. Michelle, thank you. I think it's important that your business responds to state level cannabis legislation, even if you've already established a drug and alcohol policy for your business. Without clarifying your HR policies around reasonable suspicion, employee safety, and drug testing processes, you face a greater risk of neglect, hiring practices, workers' compensation claims, and costly injuries to employees. In fact, according to the National Institute of Drug Abuse, employees who tested positive for marijuana had 55% more industrial accidents, 85% more injuries, and 75% greater absenteeism rates compared to those who tested negative.
Wow.
Yeah. So obviously this is likely due to the fact that the THC in marijuana affects depth perception, reaction time, coordination, motor skills, your sensory distortion, your focus, and of course more. Having a firmly constructed policy to bring awareness to these dangers is the first major step you can take.
So what should employers then include in their policy? What makes for an effective plan here?
A drug policy must be very specific and supported by your worksite procedures to reduce the chance of legal suits. We have construction going on, so pardon the noise, it is not us. Pardon our dust, I guess. Anyway, where was I? You want to make sure your policy includes proper management training. You guys, I cannot stress enough, your managers are your first line of defense. So you want to make sure your managers are enforcing the policies and are aware of what they are. Access to support for your employees with drug problems. You want to have an EAP assistance program, whether it's a formal assistance program or if it's something you're referring to a local resource. You want to clearly define the use of and possession parameters for your employees, establish rules for post-accident testing, in other words, reasonable suspicion, rules on how you will handle an employee's conviction. And if you don't have an in-house HR professional who's versed on workforce management or cannabis compliance, you want to obtain legal counsel. It's going to be very beneficial for your policy. Now, things to keep in mind as you're determining how best to add a marijuana policy into your handbook. You want to make sure it's including a written policy in your recruiting, as well as new hire onboarding materials to ensure that that notice is going out to individuals you're hiring. Some states require employers to accommodate an employee's use of medical marijuana. Last year, Connecticut's federal court ruled that federal contractor could not enforce its zero tolerance policy, drug policy, against a medical marijuana user. Oklahoma had something very similar, which prohibited adverse action taken by an employer that are based on findings out that an employee is a medical marijuana card holder. So make sure you're fully investigated all of your state's unique requirements. You also want to make sure you're defining the term marijuana, cannabis, or any other derivative of the drug. Simply prohibiting the use of illegal drugs can create ambiguity because of marijuana's legal status in various jurisdictions. You want to make sure you're stating explicitly that the use of marijuana, whether recreational, medically, or on the job, is strictly prohibited. Problems can arise when determining irrefutable evidence that an individual is acting impaired or high on the job and therefore warranting a drug test. This difficulty in defining what constitutes impaired behavior or physical evidence possesses the risk of becoming a case of discrimination or harassment. So record those problematic signs in writing for full transparency. And then this, of course, brings us to the subject of reasonable suspicion.
I'm going to interrupt you there, Anna. We
Okay.
have some more polling questions.
Oh, great. I love these poll questions, guys.
Yeah, helps us really understand. Okay, so get your fingers ready, everyone. Does your current handbook include a drug policy? All right. Here it comes. We're about there. So it's looking like 94%, 93% say yes. So that's good, right, Anna? They're halfway there.
Yes,
They're halfway
absolutely.
there. They've got a drug policy. Okay, so the next polling question is your handbook part of your online onboarding system? So Anna talked about how it should be, you know, in your onboarding system. Is it there? Yes, no, or I don't have an online onboarding system. Okay, we're almost getting there closely. So with we're getting almost 75% of you voted. 61% say, yep, I've got it on my online system. 13% say no, and 26% say I don't have an online onboarding system. Interesting. Well, actually, you know, that's one of the best practices here that we want to talk about. A best-of-breed onboarding platform not only makes onboarding go smoothly, but it also ensures that everyone has learned your stance on drug policies, and they have signed off that they are aware of them. So some of our clients, many of our clients, what they'll do is they'll include videos in addition to their handbooks, and they'll put them into the onboarding piece. And right there, you know, they just press the button and they have to watch the video about what does drugs do at the workplace or whatever, you know, you really want to communicate. And then after it's watched, they can sign off and attest that they've seen that. And of course, the same thing goes with reading the handbook. They can attest that they did it. So, you know, that's a best practice that you definitely want to be doing in your at your workplace. Now, at this point in the webinar, you might be thinking that, man, I've got a lot of questions for Anna, and you'd love to have maybe some time with her. So I twisted her arm, and she has volunteered that she's got a limited number of spots because she's out working with many of our clients a lot and doing HR consulting and such, but she has a limited spot. She's agreed to do some walkthroughs on best practices with some of the listeners on the line. So I'll tell you a little bit more if you're interested in that later on in our session. All right, so Anna, we're going to go back to you talking about policies. And when you think about policies, that comes up with the idea of reasonable suspicion, right? So when you think someone at work is under the influence, what are the steps? What do you do?
So I'll cover that shortly. First off, I want to say that having an electronic onboarding system is life-changing. So if you guys are using paper, it's something you definitely want to consider. because I've never personally lost a paper file anywhere. But going on to reasonable suspicion. Reasonable suspicion is a standard for identifying intoxicated personnel, whether that be over-the-counter, prescribed, illegal, or recreational drug or alcohol based on indisputable evidence. It was created as a means to prevent employers from retaliating or dissuading employees from reporting worksite accidents. By banning employers from automatically sending individuals for testing after a worksite accident.
Are there any federal rules, Anna, that regulate drug testing?
So no, not for the private sector at least. Regulations are largely left to the state level since cannabis is still a federally outlawed controlled substance, as Jennifer had mentioned earlier. For instance, in Arizona, state legislation conditions that employees can contest or explain positive results. Or in Illinois, employers are required to allow employees the privacy to use prohibited substances off the clock.
So what kind of testing scenarios then are common?
So the most common, I think, are the pre-employment scenario, reasonable suspicion, post-accident, returning to duty, and of course there's random drug testing.
Okay. So if you have received a complaint about an employee, what do you do?
Well, let me talk through that scenario. You first receive a complaint, so that's your first step, and how to process that you'll need to follow to document and verify your reasonable suspicion. So the first and second steps are concerned with registering those early warning signs and deciding whether or not they justify further action. The first step is you receive a complaint, right? When it comes to receiving complaints, you want to make sure you're not just immediately sending them out for testing. You need some reasonable suspicion, not hearsay or gossip. In other words, to have reasonable suspicion, you need to take a statement of the observation. Who, what, where, when they saw what, and ask what behaviors they witnessed specifically, and look for corroborating testimonies and possible previous incidents.
So what happens if an employee makes a complaint that they thought, let's say Jane, was under the influence at work last week?
Michelle, that is an excellent question because that's probably going to be happening quite a bit. The very first thing you should do is, again, document that report. Ask the employee to step forward immediately if they witness anything in the future, and follow the same steps as if you were investigating a fresh report. What was observed, when, if anyone else can corroborate it. And since, again, it's not a fresh incident, you're only going to be able to document this issue and have it as, I call it, a cold case file. Should the situation come up in the future, you have something to reference.
Okay.
And the second step is to obviously observe the behavior, and this should be done by two members of management separately. So you want to reference your behaviors checklist to know what signs to look for, observe them from afar, how they're interacting in their workspace, talk to the employee directly to be able to establish validity of the complaint.
So when you address that employee, when you talk to them, should you mention that you were there because of a complaint, or how much should you tell them?
Yeah, ideally you don't want to reveal too much at this point. You're just investigating. You don't know what the outcome is going to be yet. So step 3 is to remove that employee from a safety-sensitive area. While you're continuing your investigation, make sure to remove that employee from any possible harmful situations. Any heavy machinery or power tools if they're using them. If they're driving a forklift, make sure to get them off of that.
Yeah, that'd be pretty important.
Yeah. Step 4, it's going to require you to have another person observe the behavior. So as I mentioned, you want to have 2 members of management, at least one level higher than the employee under investigation, should be making those observations immediately upon the notice of the complaint, separately. And then next, with step 5, you must document what's observed. Make sure you note the demeanor, appearance, the eyes, dilation, the smell, anything on their face, breath, mannerisms, walking, speech, anything to that, you want to note it. A full observation checklist is available for you, and we also actually have a full webinar on reasonable suspicion that you can reference as well.
Okay. Hey, can you videotape an employee who is suspected of being, under the influence?
That really depends on your state and your company policy. Many states do require dual consent.
Okay. Do you think you should have training if you are going to be in a situation where you have to identify these signs or symptoms?
Having training would definitely be a best practice to have all of your managers go through such a training. Training is offered by the DOT as well as the Substance Abuse and Medical Health Services Administration.
Oh, okay.
So next is step 6, and you'll need to assess what the next best course of action is based on the previous steps we just talked about.
So what do you do when both witnesses, I guess, agree that there is no reasonable suspicion at that time?
Well, when that happens, you simply document what has been done and your findings. And once again, it turns into a cold case file.
Okay. So if the manager is the person behind the complaint, can the manager also be the one to observe?
Absolutely.
Okay.
So for step 7, you need to meet with the employee. That can be a little awkward. So you want to make sure you have a witness in the room. Tell the employee that a complaint has been filed. Cite the drug and alcohol policy of your company and explain the procedure you followed. You've had multiple observers, what was observed. Allow the employee to respond to the complaint and take note of that response. Have the employee sign a testing acknowledgement form and share the next step with the employee listed on the consent form.
So can the manager who was involved in the observation process act as a witness during this meeting you were talking about?
Yeah, actually they can. They're just acting as a witness at this point. You certainly don't want to reveal to them that they were directly observing the employee.
Okay. So would you show the employee the sheet of observations? Can you list them out and show it to the employee?
Not necessarily. I wouldn't, just because it's going to have the name of the witnesses, and you want to keep it.
Okay.
Yeah. So I also want to say I would recommend you use the wording, we are sending you for testing to rule out the possibility of a violation of the drug and alcohol-free policy. So a wording is going to assume innocence rather than guilt, hopefully putting that employee at some ease. It is going to be a stressful situation for them.
No, definitely. But that's interesting, the words you use, rule out the possibility. Okay.
Now, for step 8, it's important to arrange for transportation for that employee. I cannot stress this enough. You cannot have an employee transport themselves if there's any concern that they're under the influence of something. You could be liable for an accident, so you want to guarantee that they arrive by the appointment by some other means. It's important to do so quickly because if too much time passes, the employee's results could be different with time. And then you're left with nothing but your observations. Now, again, just as Jennifer had mentioned earlier, unlike alcohol, marijuana impairment does not reflect to a specific level of THC in the body, and therefore impairment cannot be determined by a specific test at this point. So this is that catch-22 that we're now facing.
Okay. So, all right, after the test, can the employee come back to work?
Oh, I know. I know the pressure of having a missing employee and having them out, and the workload is piling up. As a best practice, I highly recommend just wait until you actually get the results.
Okay. So what if the results are positive? Then what?
So if the results are positive, you need to respond appropriately. So if you have an EAP program, an employee assistance program, you want to provide that employee with the contact information, no matter what the outcome is, whether they're continuing employment or not. You can offer a last chance agreement, allowing that employee to seek counseling, treatment, or both, with the understanding that another instance would result in termination. You can seek legal counsel on how to proceed, or if it's your company's practice to do so, you can simply terminate immediately based on your company practices. If the results are negative, which is what we're all hoping for, right? You contact that employee as soon as possible to convey those results. You let that employee know what the next steps are, basically when they're returning to work and what their back pay will be.
Okay. All right, so I'm sure you've had this happen. What happens if they refuse to take the drug test?
Of course it happens It's very important to have the consequences of refusing to test clearly stated in your policy. So if you refuse to test, it could result in an automatic positive test result or an automatic termination. If they refuse a cab ride, because that can also happen, don't restrain the employee by all means. Keep your hands off. If possible, and they're more likely to do this actually if they're refusing something, have them sign off on an acknowledgement form attesting that they're refusing to do so. And, you know, if you feel that they're under the influence, call the relevant authorities. They're putting themselves in danger as well as others. So let the authorities know if you have their, you know, license information, share that with them.
Okay. All right. Well, it's time for our final polling question. One last question. So we'd like to know, how do you currently track issues with your employees when it comes to like reasonable suspicion, or even if they're absent because maybe they are doing drugs, whatever, but how do you track that? Do you use just a paper file? Do you have some sort of online performance management system, or do you not really track? When you're suspecting there's something going on. Okay, just a couple more seconds here. Wow, very interesting here. So Anna, 48% of our listeners use paper, and 19%, oh, actually I skipped an answer, use Word docs on a manager's computer, sorry. And then 28% online performance management system, and 4% don't really track it. So the good news is everybody's tracking pretty much, right? And they're just using different things. So another best practice obviously is our clients like to track these things, and a good performance management tool allows you to do it real time. If you can see up on the screen here, just for each employee, boom, you bring it up, and right there you put in what your observations are, and it's all recorded forever there. And you can do that whether you're noticing strange behavior, or if they showed up late again, or, you know, they didn't come in at all. Of course, your time and attendance will track that too, but you obviously want to track some weird things here in the performance management system. Yeah. So another best practice, Anna, and I know this is an area that you do a lot, is training. And of course, you want to do training on site, you know, if you can, but a lot of you, again, a lot of our clients, they're distributed. They're in a lot of different places. So doing training in person can be very difficult.
Plus tracks the outcomes of
it, yeah. So best practices is what we see, and Anna, jump in here, is when clients use a learning management system, and then they can assign those classes, people take the classes, and then they have to answer a few questions and get tested.
Yeah, and then the beauty of it, it's just accessible just as easily. So if there's ever a question on who's taken what, or, you know, harassment training comes to mind immediately. You know, oftentimes people plead ignorance, they didn't know. There's no question on whether or not they've taken the training because it's reportable.
Yeah. So another best practice is really the absenteeism that comes with this, you know, drug use or alcohol use for that matter, because people obviously are having trouble getting to work. So you want a good time and attendance system, a good workforce management system where you can track attendance, right? And you can see who's coming in late or not at all, and then have that feed into an employee point system so that you can gather points as they have more and more infractions. And then HR and management has noticed, okay, they're now at 4 points, so it's a verbal warning.
Right.
They're now at 6 points, it's a written. They're now at 7, it's time to terminate. So that combination of a good time and labor with points system can really be helpful. And we see clients really making headway here.
Absolutely.
And then finally, another best practice is, you know, having some analytical tools so that you can look at the terminations and people that are leaving. You're looking at voluntary versus involuntary dismissal. So have a system, a tool where you kind of dig in, all right, give me everybody that's involuntary, and then I know these are kind of small, but then you go into the next, drill down more, and you say, give me the reasons why we had to let them go. And, you know, it could be drug use or whatever. But what's key is you got to be able to look at it at a site level or a supervisor level. So if you can see on the screen on the left, those are numbers, those are specific sites. So you can say, hey, you know, Emma's location is really having a lot of problems with drug issues. We need to do some real special training out there, right?
I love having this bird's eye view. It really does pinpoint your problematic areas and what you need to focus on.
Well, we're ready for some questions. So I know we've covered a lot of information today. So type in your questions, and then while those questions are coming in, I just want to talk to you about a couple of webinars that are coming up and some of our sponsors. So first of all, our sponsors, these are folks we work with all year long that really help us and present on these webinars. Duane Morris, of course, is an 800 attorney law firm across the nation, across the globe, and not only just in Illinois like Jennifer, but great organization, is our partner on a lot of our webinars. Talent Rise is a new partner, a lot of HR consulting services and executive recruiting, and then the Human Capital Management Institute. They're experts in analytics and consulting and data scientists, so really helpful there. So, hey, a couple of webinars. Now, as I told you, our webinars fill up. And so we really want everybody that's on today's call to have a chance to get to these extra webinars and get some more education. And so I hope you don't mind, but we went ahead and like pre-enrolled you for these webinars. If you can't make it or you don't want to go, just tell us in the survey, no big deal. But we really wanted to save you guys some seats because these are going to be some good ones. Reducing labor spend in the wake of rising costs. So in this one, this is presented by Human Capital Management Institute, the CEO, Jeff Higgins, and we're going to talk about using data to target hiring and operational problems that inflate your costs. So using the data to really dig down and down to that site or supervisor level. So you definitely might want to invite your CFO, your CEO, your controller, your ops people to this one. And then the other one is in May 6th. Now, this one is going to be a panel. It's going to be a virtual panel led by Carl Kutzmode of Talent Rise. And in there, we're going to be talking about some creative ways to recruit and practices to help retain your workforce. So this panel, we're going to have, I think, Valvoline, and I also heard possibly Dent Wizard. So different employers of large hourly workforces, they're going to be here with us virtually for an hour to talk about recruiting and retaining.
Sounds really exciting.
Yeah. So again, we know you're busy, so we pre-enrolled you for these, and just let us know if you want us to take you out. There'll be a survey at the end. You can tell us that. But definitely think about who you might want to be including in these webinars to join you. Again, we encourage you to enroll now because we only have a limited amount of seats, so we want you guys to have a first right at them. All right. Do we have some questions? All right. So I am in Illinois and had an applicant tell me he has a card for cannabis, but uses it all day long. Our company doesn't want it used on the premises. So how should we handle this?
So this is Jennifer. So first and foremost, we have to start with your policy. So in advance, as Anna went over, we need to establish what is your company's policy on marijuana. If you don't have any prohibition on marijuana, marijuana is now a lawful substance, both medical and recreationally. And when we say uses it all day long, what does that mean? Does that mean he is literally smoking it in your workplace? But Illinois is a no smoking state. So do we need edibles? There's a lot of different questions arising in that situation. So it is a scenario that you can look into. First steps first is to see what you've decided as a company on that position. I do encourage all employers in Illinois and any of the other 11 recreational states to have made a decision on what you feel about cannabis up front and get that into your policies, and then that will guide you from there.
Jennifer, you literally took the words right out of my mouth. I also wanted to say, because it's medical marijuana, would it be possibly an exception or an accommodation being made depending on the situation.
Yeah, and that again, that's going to depend in Illinois under our Medical Act. You still need to go through an interactive process. He definitely has a medical condition. And so what steps do you need to take? Our law says that you do not have to permit marijuana use on campus. However, are we certain that's what's going on? I have a lot of caveats with that question. So that'd be one that you would want to drill down into very carefully before making any decision. And in all likelihood, I'll be honest with you, not to promote our services, but consulting with legal counsel on all of your medical marijuana issues is advisable.
Especially since it's so new.
Correct.
Okay, we got time for one more question. This is coming in from Sally. We operate in a state that has legalized medical use of marijuana. However, our workers' comp carrier said that if any employee was injured, that person would not be covered regardless if the employee stated the medical use was done at home, but post-accident drug test was positive. So I guess the question is, what do you do in that type of a situation?
So I know Illinois is starting to address that, and we'll get more and more guidance from the courts as the years go on. But for instance, here in Illinois, we have recently had a court case that said, and I don't really recall whether, well, it would have had to have been a medical situation. An employee that tested positive, that was not an exclusionary factor in and of itself. The person may be otherwise excludable from workers' compensation for other reasons, but simply that factor, standing alone in a vacuum, the court found that that was not an excluding issue. So this will come up. We will get more guidance on it. And your policy may have different things, but it is going to be a hotly litigated issue. And again, I hate to say this, and I know people hate to hear from their lawyers saying this, but consulting with legal counsel to make sure your counsel agrees with whatever your workers' comp carrier is saying is definitely advisable.
Right, and I would actually work with the workers' comp company as well, and kind of go over, well, they're legally able to do this, so they have to be covered by workers' comp, in my opinion. I'll just leave it there because there are a lot of caveats.
There is. All right, great question. So you'll have an opportunity, if you'd like, we're going to show their phone numbers and emails, so if you have some more questions. Again, just to wrap up, thank you very much, Jennifer, Anna, really appreciate your expertise. I'm sure we could go on for hours and hours on this topic.
Absolutely. Thank you, everyone, for joining. I hope you guys found this helpful.
Thanks, Jennifer.
Thank you, everyone. My pleasure.
All right. Again, EPAY, we are a full suite human capital management provider, from applicant tracking all the way through to performance management. And again, remember I talked about in the middle that you might be a little hungry for some more information. So as I mentioned earlier, Anna has kindly agreed to do a few best practice walkthroughs. Thanks, Anna.
Sure.
So during these walkthroughs, Anna will review key areas where you could fall into some pitfalls. So hiring, onboarding, compliance on, time and attendance, all those different areas. So about a half an hour of her time, and she'll go through and kind of walk through in the different areas where you need to be compliant and so on. So just let us know on the survey if you'd be interested. It's complimentary, and if you'd like to, talk with Anna, take advantage of this complimentary opportunity. And of course, on the survey, don't forget to give us, if you have friends, colleagues, your boss, your CEO, your CFO that should come to these other webinars, just put in their emails. Now, we will, of course, send you a bunch of our emails afterwards, and you'll have an opportunity to forward an invitation too. But again, limited seats. I can't stress that enough, and we'd like to see you back. The next one is really on controlling your labor costs in a rising cost environment. So again, thank you so much to our sponsors. Up here is Jennifer's number and email and Anna's. You will get a copy of these slides and a recording, so don't worry, that'll come in. But we look forward to talking to you in the future, and please connect with us on LinkedIn or Twitter so you can see. We do classes every 6 weeks so that you can come to our sessions. So again, thank you very much. At EPAY, we'd like to be your human capital management provider. Please enjoy the rest of your day.